Hello everyone, my name is Satyam Shivaach and I'm working as a legal intern with LEXIS and Company. And in this video, we will discuss about the Indian Forest Act in 1927. Forests are one of the essential natural resources available in our country, and it covers one-third of the total Earth's area. The forest acts as a guardian and protector of our wildlife in our country. Forests are means of generating revenue for the state by supplying various raw material in its most natural form to the industries globally. They are reason behind climate change and in controlling the quality of air and water. The forests are in use in the hand of the majority population, due to which the resources available are being consumed at an alarming rate, resulting in the depletion. The users of the forest have recklessly utilized the forest and cultivated and destroyed them in the name of agriculture and other personal consumption of food, timber, fuel, and fodder. The need of a legislation protecting the regulating which regulates the forest are required, which are met by the Indian Forest Act 1927, which imposed governmental control over the forest by classifying them into the reserved, protective, and village forest. Now, what is the Indian Forest Act 1927? In 1927, a revised legislation of the Indian Forest Act was enacted based on the previous Indian Forest Acts, implemented under the British. Just like the preamble of the Constitution that lays down the objective, very legislation has its preamble, wherein the objective and guidelines of the particular act are listed. The preamble of the Indian Forest Act seeks to consolidate the law relating to forest, the regulation of and the transit of forest produce, and to levy duty on timber and other forest produce. It also consists of the procedure followed in the case of declaring the area to be reserved, protected of a village forest. The Act is divided into 13 chapters and total of 86 sections, ranging from the definition of various forests to the penalties that are to levied on the violation of the provision of this Act. The term forest has a wider ambit when it comes to its definition, as it includes private land, land for pasture, cultivable lands, and so the Supreme Court yet assign a particular interpretation, and thus the Act is silent on the definition of forest or of forest land. Now let's see what are reserved forests. The reserved forests are dealt with chapter 2nd of the Act, ranging from section 3 to 27. In simple words, the forest land or waste land to which the government has an ownership is a reserved forest. These forests are restrictive as the government has priority right over the land. The use of the forest land is prohibited to the local people unless they have permission by the government. The area of land is declared to be reserved forest when the government issue a preliminary notification under section 4 of the Act, declaring that the such land to be constituted as a reserved forest, and the forest settlement officer settles all the right either by administering or rejecting them. Section 26 of this Act deals with the prohibition of number of activities, including grazing, free-feeling, burning, quarrying or hunting, etc. in the forest. The penalty for the violation of the provision of Section 26 is imprisonment for a term which may extend to 2 years or a fine which may extend to 20,000. Now let's see what are village forests. Following the order of the section under this Act, the village forests are dealt with the next chapter in chapter 3 of the Act under section 28. When the government assigns any relevant forest or any other land to the village community of their and use a piece of land is classified village forest land. As according to the Act, the state government makes rules and regulations regarding the regulation of management of these forests. The term village forest and forest village are interchangeably used in certain cases, but are eventually different in their meaning. While village forest is a legal category under the Indian Forest Act, the forest village is merely an administrative category. Although the latter is recognized by the forest department, the revenue benefits cannot accrue to such village as they are not technically under the revenue department. Generally, the land given to the village forest are constituted into the village grazing reserve. Now, what are the protective forests? The state government is empowered to constitute any land other than the reserve forest as protective forest, over which the government has proprietary right. The provision of the protected forest are dealt with in chapter 4 of the section 26 of this Act. In the case of these forests, the government retains the power to issue rules regarding the use of forest, and if in case where there are no rules, the practice are allowed. Along with the right, the government also have the power to reserve the specific tree species in the protected forest. The sole reason behind this is those particular trees have the revenue raising potential and are thus required to be protected for the benefits of the economy. Chapter 5 of the Act deals with another type of forest named non-government forest or other private forest. Considering the other forests to be owned and regulated by the government, these forest lands are not in control of the government, though the state government may by notification prohibit and regulate the clearing of land for various purposes which comes under the government power only in special circumstances like to be preserved public health and welfare. One of the objectives of the Act regarding the levying of duty on timber and other forest produce is dealt with in Chapter 6, which extends to the produce that takes place in the territories and in under government control. Now let's see the procedure for settlement of rights. The Act was merely incorporated to differentiate the types of forest, while the protecting their use and well as the regulating the forest produce. The classification of forest involves the right of the government and determines how a forest or a waste land becomes a reserved or protected forest. The procedure requires a forest settlement officer to consider the claim made by the local inhabitants regarding the usage of the land. Later make decision based on its direction, either to accept or to relocate or to discontinue the practice. The government in its first required to notify as per Section 4 of the Act that the particular piece of land is going to be labelled as a reserved or protected forest. As per Section 6 of the Act, the FSO may call for an examination of a person who he thinks may have a knowledge of the fact, including the evidence of any of the person likely to be acquitted with the same. No new right is to be notified land may arise after such a notification has been issued, and those claiming any pre-existing rights have a period of at least 3 months to appear and assert such a right, and to make a case for compensation. However, there still exists an assertion period in extraordinary cases until the final reservation order gets published. The Act is inclusive of the provisions that are necessary considering the protection of the forest and their regulation. Further, the Act deals with the seizure of property of the forest or police officer, where if he has the reason to believe that there is any commission of offence with respect to the forest produce, the phrase reason to believe is subject to the provision, substitution and material evidence in custody of the offender. The officers are required to put a mark on the property being seized and have a prepare a report which is then produced before the magistrate having jurisdiction of the matter. The Act also ensures that the power are granted to the forest officer by the state government with relation to entering upon the land to conduct a survey, issue search warrant, conducting inquiry and recording evidence for the same. These evidence are then admissible in the trial before magistrate. That is all for today's video. Thank you for watching. Please like, share and subscribe.